Excellent question. Here's a look at the international perspective of environmental law, including its origins, principles, and current state. Origins and development. Early recognition. While concerns about transboundary pollution existed much earlier, the 1972 United Nations Conference on the Human Environment in Stockholm marked a significant turning point. It solidified the concept that environmental protection was a global concern. Growth of treaties and agreements. Decades following Stockholm saw a massive increase in international environmental treaties addressing issues like biodiversity conservation, protection of the ozone layer, climate change, trade in endangered species, management of hazardous waste, customary international law. Over time, certain core principles evolved into customary international law, binding on all states even if they haven't ratified particular treaties. Key principles. International environmental law rests on several foundational principles. Sustainable development. Development should meet the needs of the present without compromising the ability of future generations to meet their own needs. Precautionary principle. If an action might cause severe environmental harm, lack of scientific certainty shouldn't prevent precautionary measures. Polluter pays principle. Those who cause pollution should bear the costs of preventing and remedying its effects. Common but differentiated responsibilities, CBDR. While all states share the responsibility of environmental protection, developed countries shoulder a heavier burden due to their greater historical contributions to environmental problems. Major international agreements. Some key milestones in international environmental law include Convention on Biological Diversity, CBD, aims to conserve biodiversity, ensure its sustainable use, and the equitable sharing of benefits from genetic resources. United Nations Framework Convention on Climate Change, UNFCCC, provides the foundation for international efforts to combat climate change, with subsequent additions like the Kyoto Protocol and the Paris Agreement. Montreal Protocol, a successful example of global cooperation, focused on phasing out substances damaging the ozone layer. Convention on International Trade in Endangered Species of Wild Fauna and Flora, CITES, regulates international trade in protected plant and animal species. Institutions and organizations. Various international bodies play a central role in shaping and enforcing international environmental law. United Nations Environment Programme, UNEP, core UN agency coordinating global environmental actions, administering agreements, and supporting countries. International Court of Justice, ICJ, the principal judicial organ of the UN, which settles disputes between states, including matters related to the environment. Specialized environmental tribunals. Certain treaties establish their own tribunals or dispute resolution mechanisms specifically for environmental issues. Challenges and ongoing evolution. Enforcement. Difficulties exist in enforcing international agreements, as many rely on voluntary compliance and diplomatic measures. Addressing global inequalities, striking a balance between environmental protection and development needs of less developed nations.